Thank you. You can now resume the inquiry for cross-examination, was it not? Yes.
Thank you, sir. Mr. Williams, topic 1 is matters of approach. Can we start, please, with the local plan CD 2.1, and when you're there, go to the allocation on page 282, please.
Yes, I have that.
Thank you. Now, this, we can agree, is a critically important policy in the design of any development on the appeal site, isn't it?
Yes.
When we look at paragraph 1, this tells us that it is allocated for the development of approximately 100 dwellings at an average density of approximately 30 dwellings per hectare, together with the associated open space and infrastructure on land south of Kenward Road. The number of dwellings is approximate, and therefore it is not fixed at 100, is it?
Correct.
And therefore an essential part of the design process for this site is to determine the quantum of dwellings, isn't it?
It is. It's obviously, yes, it is. It's obviously informed by that policy, and there's a process has gone into the identification of the policy as to the approximate capacity. So there is a starting point.
Density, similarly, that is also approximate, so it too is not fixed at 30 dwellings per hectare, is it?
Correct. We heard earlier about the relationship, and I'll leave this point to my planning colleagues, but there's a relationship between this policy and other policies in terms of density.
Yeah. And therefore, again, an essential part of the design process is also to determine the density of dwellings in any proposed development, yes?
Not quite, because a density is a product of a good design. You do not design saying, right, I'm going to try and achieve this density. Density is a product of layout, housing mix, etc. So you don't target a density when you're designing. You design according to other factors: landscape, character, housing mix.
You don't target density, but when you go through your design process, you will assess what the densities are that your different design options are producing, wouldn't you?
You conclude saying, this is the right design approach, the right principles, this is the resulting density, yes.
And when we are looking at the quantum of dwellings, the allocation gives us some parameters for that exercise, and that parameter is it must be approximately 100 dwellings. You agree?
That's what the policy says, yes.
And working out the quantum of dwellings within that parameter of approximately 100 dwellings, that too is a matter that needs to be tackled and accomplished as part of the design process, doesn't it?
Yes, it does, yeah.
Now, your proof of evidence, please.
Yes.
Paragraph 3.2.14 on your page 18 in the hard copy, and it's PDF page 10.
Yes.
In light of what we've just agreed, it is correct, as the council statement of case put it, that the determination of the quantum within the parameters set by the application is by the allocation, is a matter that is left for the application stage, isn't it?
It is, but at 3.2.14 I'm referring to the specific point relating to the LVIA process, which is condition 5 and 15 of that policy.
Yeah, but if you look at, let's go back to the statement of case so you can see it. So that's CD 10.2.
Yes, I have that.
And if you look at page 10 PDF, it's paragraph 34.4 that you're referring to. And you're referring to the second sentence. So it's top PDF page 11. The council said this: instead, the detailed assessment of quantum was left for the application stage, i.e. now within the parameters set by allocation. That is a statement that you agree with, isn't it, given the answers you've just given to me?
The detailed assessment of quantum is a refinement of where the policy currently is.
Yes.
The policy sets a very clear starting point.
Yes.
My reference at my 3.2.14 is specifically relating to the LVIA role in shaping that point.
Right. Okay, but leave aside the LVIA role, you would agree that it might not be the LVIA, maybe some other part of your design process. That might be your view. But whichever part you wish to put it in, that is something which needs to be determined now at the application stage within the parameters of the allocation, correct?
Yeah, yes, that's right. The parameters will clearly have to identify the quantum. As I said earlier, that really is a product of the right design process, but it's informed by the policy.
And given what you said a few minutes ago, you would take the figure in the allocation as your starting point, yes?
Well, I think it's informing the expectation the council has on what will result from the allocation. So it's got to be a starting point, or part of that starting point, to understand expectation. Yes.
Right, thank you. Back to your proof of evidence, same page you were on before, but slightly earlier, please. 3.2.9, paragraph 3.2.9, at the top of page 8, PDF page 10.
Yes.
From that starting point, the number that you hit upon should be above or below that starting point in your view.
So you're referring to 329?
Yeah.
Yes, I mean, that's my consideration of my assessment process.
Yes.
And in effect, what I'm doing is trying to not get into a debate about what approximate means.
Yes, so that's your view there. I fully understand that. But what I want to look at is what you say slightly earlier in your proof, your page 3, paragraph 2.2.2. You say, and in fairness to you, you're not reporting your own view, you're reporting what you've been told. You say in the final sentence that the allocation which you are advised is for a minimum of 100 units and approximately 100 units. So there's a conflict. The view that you give us at your 3.2.9 is your view, is it could be above or below the starting point, but you've been told by somebody else, as you report here, that that's not the approach to adopt. That's fair, isn't it?
Certainly 2.2.2 sets out two positions. One position is the interrelationship with the planning case, which we've heard earlier, which is the interpretation of the allocation in respect to the expectation of a minimum. My evidence at 329 doesn't get involved in that debate. It's simply trying to understand as a starting point the expectation of what the allocation is, anticipating and therefore the harm it's accepting to measure the appeal scheme against.
And what we see at your 3.2.9 is your approach as a landscape architect, as an urban designer, isn't it?
Yes, it is. It's my approach of trying to understand what my evidence should be trying to assess, and that is the gap between the anticipated capacity or form at allocation stage in the appeal scheme.
If planning permission is granted by the inspector, as your client seeks, then the acceptability of 112 dwellings on the appeal site will have been established, won't it?
If it's permitted?
Yes.
Yes.
Go to your rebuttal proof of evidence, please.
Up to 112, I should say.
Yeah. Go to your rebuttal proof of evidence, please. Paragraph 2.3.21, which you see at the top of page 7, PDF page 9.
Yes.
At your final sentence, in any event, you say the 112 is a maximum limit, and if there was a justifiable reason at reserve matter stage, when layout, appearance, landscape scale, and access are all considered in detail to not meet this maximum amount applied for, the number could be reduced. But to be very clear, the council at the reserve matter stage couldn't require a reduction in the number. That would have to be something that your client agreed, or whoever brings forward the reserve matters application agreed to, correct?
The echoing is quite difficult to hear,
very sorry.
but I think what you said was that the council couldn't...
We can't. The final sentence of your 2.3.21.
Yes.
The council could not insist on fewer than 112 dwellings at the reserve matter stage, could it?
Yes, they absolutely could.
You think the council could?
Absolutely, yeah. Because that would be a product of design. It wouldn't be a starting point to say, right, we don't want 112 in the RM, we only want 108. it would be a product of the agreement of a number of aspects, which I touched on in chief. There would be detailed consideration of highways and landscape and housing mix.
Okay.
So, for example, a quite important point to make, for example, the scheme at the moment anticipates 14% of the units to be flats to meet a housing mix that's come from the Schmal. If that changes, and let's say we remove all of those, that would not change the coverage, it would not change the block structure, it would not change the plot ratio density, it would reduce the number of units without any change. So that just that simple strand of consideration at reserve matters could automatically lead to a change in the overall quantum. So, and that's quite common.
I'm going to put it to you really clearly. When you bring forward your reserve matters, if the council does not like the design,
Yes.
and that design is an inevitable consequence of 112 dwellings, yes?
Yes.
The council cannot, at that point, tell you to reduce your figure from 112. The council has to live with the consequences of 112, doesn't it?
No, that's absolutely wrong.
Okay, well,
I mean, fundamentally wrong. That schemes that we get involved in, month out, have those discussions. So that, I mean, if we work on that premise, that really is wrong.
Right, okay. Well, it's useful to know your position. The inspector needs to be satisfied now that a quantum of 112 dwellings can come forward acceptably on the appeal site, doesn't he?
The inspector has to... It's not quite as firm as that for the reason the answer I gave previously. There has to be a reasonable prospect of 112 being acceptable. But for all the reasons I discussed, there are variable elements that one has to have trust in the reserve matters process. The example I gave you is one of those, that the mix could change, and because of a changing mix, 112 wouldn't be achievable.
So do you accept, in very simple terms, do you accept that the principle of 112 dwellings would actually be determined and decided by the grant of outline permission or not?
Up to 112 would be determined by grant of outline permission, up to.
So is your evidence to the inspector, in light of the answers you've given me, is your evidence to the inspector that a scheme up to 112
Yes.
could come forward acceptably? That's essentially your conclusion, isn't it?
Yes, the illustrative layout assumes a mix and demonstrates one way in which 112 units could be achieved, but that is not guaranteeing or confirming that 112 units will be the result of the reserve matters.
No, it's not guaranteeing or confirming, but slightly more than that. Because you're not guaranteeing or confirming that, you are not saying to the inspector that 112, that specific number, your evidence is that sorry, let me put that again. On the specific number of 112, your evidence to the inspector is not that you are certain that could come forward acceptably. That's not the position you take. You take a different position where you say up to, correct?
Yes, but I'm also saying that in light of the principles that are embedded within the outline permission, informed by my analysis of the illustrative layout, which in turn is assuming a certain mix as set out in the DAS. On that basis, I'm comfortable that 112 can be delivered, but I've caveated that, being clear of all the things that are likely to change at RM stage that may or may not lead to that up to figure being achieved.
And if the question is the one that I put, which is the inspector needs to be satisfied that 112 exactly could come forward acceptably, if that is the question, that is not a question which your evidence addresses, correct?
I don't specifically address that question, no.
Thank you.
I mean, what I do is set out, I think pretty clearly that the net developable area is the same as the council have expected in the allocation, and then whether it gets to 112 is whether the maximum density of 33.4, given those other factors, is achievable.
Yeah, and whether it gets to 112, having regard to those other factors, is not a judgment that you can reach today in your view. That's right, isn't it?
I missed that last
Yeah,
bit, sorry.
whether we can get to 112, having regard to the factors that you've just listed, that is a judgment which you can't reach today because you think that's a judgment that we need to do at stage 2, correct?
My judgment today is it can be met based on the housing mix and assumptions that the outline scheme makes, but all those considerations need to be re-investigated at reserve matter stage because there are other variables that would be affected at that stage of the application process.
Right, and you've applied the approach that you've just explained to me, including your reasonable prospect test, yes? So you've applied, in saying, in giving me the answer you've just given, that is on the basis of the approach you've just set out, isn't it?
Yes.
Right, thank you. The design process, please. Your client knew from the Regulation 18 draft plan in December 2020 that the council had in mind an allocation of approximately 100 dwellings, didn't it? Do you want to see that, or do you know that?
I will take it as read.
Right,
I think
well,
that's...
so it's CD 4.4 at page 246. The DAS refers... Yes, of course, look at... Well, I'll take you there in case there's any issue. CD 4.4, page 246. And it's PDF 247. And you'll see at the top of that, it's slightly differently formatted, but words you're familiar with. Approximately 100 dwellings. Do you see that?
I can see that, yes.
Yeah, and that helpfully at the top, you see it says December 2020.
Yes, I can see that.
So that's that starting point. The DAS refers to the allocation. Let's have a quick look at that. That's CD 5.4. We've been there before. Page 8. And we get, it's PDF 8, hard copy 6. So are you on the PDFs? You are, great. I think everybody is. Top paragraph. The emerging Maidstone local plan proposes the allocation of the northern parcel for the development of approximately 100 dwellings at an average density of approximately 30 dwellings per hectare, along with the southern parcel.
Yes.
What the DAS doesn't tell us is whether that was treated as a minimum or not, does it? Can you help me on that? Did the design team understand the 100 dwellings to be a minimum? Is that something you know?
I've not checked that point, but I couldn't be certain how they've regarded that. I can be certain about how the design process has evolved through that, but
you're not sure.
It's clearly from the early options they were looking at layouts and options that were above that.
Yeah, that's absolutely fine. All grist to the mill tomorrow. I'll bracket those and we'll come back to them tomorrow. It's only because they were design related, so Mr. Williams. That's fine. No, I'll ask Mr. Ross tomorrow. Let's just topic 2 then. Let's look at what is definitely your remit, which is the option process. In the DAS, please.
Yes.
I mean, we can agree just as a matter of principle that one of the main purposes of the DAS is to tell the story for the design concept and how that's evolved, yes?
It's one of its requirements is to explain how it's evolved, yes.
Yeah. If we start, please, at page 24, PDF 26.
Yes.
We've got the 3 options here. You've told us that these were before the landscape modelling and assessment began, that's right?
Before the detailed modelling of the internal landscape began, but the landscape architect was involved at this stage.
Okay. What date were these options? Can you help me with that?
I don't know precisely.
Okay. And can you help me with how many dwellings were in each of these options?
I believe they're all 125.
125. Okay.
Actually, that might be wrong because
Yes,
I think
maybe that's for Mr. Ross tomorrow, but
yes,
do you not think this starts at, well, I'll ask Mr. Ross tomorrow then. You can do your homework, Mr. Ross, and come equipped with the answer. What we then get when we turn over the...
well, option one is effectively the same as option 2, but without the units south. So I think
Yeah.
So there is
got to be
a
more.
difference there. Yeah.
Yeah, exactly. It's got to be more. Okay, well, we'll find out tomorrow the true numbers. You've given us the best answer that you have. But if we look forward then to the next page, PDF 25, page 27, PDF 27, internal 25, we get the vision document and the further refinement. We know that the vision document, that was 125 units, wasn't it?
Yes.
And that went in to the LPA for the formal pre-application advice, didn't it? We see that. Yes.
Sorry, I missed that.
Yes, that was what was submitted to the LPA for the formal pre-application advice. Yes.
It was. I think other plans were sent in as well. Yeah.
And then we get the further reduction from that, which is to 112, isn't it? Which is what we see before the inspector today. Yes.
Yeah, it doesn't happen quite as immediately as that. It goes through a process, as I described in chief. So, yeah, there's various refinements that took place. There were options that kept that number that looked to include internal landscape. Then there was pre-app meetings and discussions on specific changes and comments that reduced it to 112. So 112 came out of that design process, including interaction with the LVA process, but also then the interaction with the authority.
And the direction of travel we have is from a figure of 125 or possibly a bit more in the initial options down to 112. That was the direction of travel of the design process, wasn't it?
Yeah, it was. Yeah.
This wasn't a design process that started at 100 and thought about options around that starting point, was it? It started at a much higher figure and it got progressively watered down through engagement with the council and other consultation, yes?
Sort of, yeah. I mean, it started with options looking afresh at the land, with the role and responsibility of making effective use of land. So it started with that. It went through a consultative process to choose a primary option. It then explored refinement of that then included interaction with the LVA, modelling vegetation, talking to the authority, and that's what led to the reduction in numbers.
Fine.
So it wasn't quite as direct as you suggested.
Okay. But whilst that direction of travel is ongoing, the design team will have known from at least 2020, December of 2020, that the LPA's expectation was actually quite different. It was approximately 100, yes? You see that?
Yeah, but at that point, yes, but...
Thank you.
At that point, no one's saying, well, approximately means X or Y. The design team has a core responsibility to make effective use of land.
Yeah. And in terms of where we started with an allocation giving you a starting point and then considering options around that, we don't see any contemporaneous evidence of capacity testing around that number, a little bit below 95, a little bit above. We don't have any evidence in the DAS that was an exercise undertaken, was it?
No, because the natural process was that's the starting point for the allocation. Let's gather technical information about the site. Let's understand constraints, which an allocation couldn't understand. Let's respond to the site issues in the way that the evolution of the scheme has. And the capacity that comes out of that is a product of accommodating those constraints and a housing mix that would lead to a given number. So I don't see anything wrong with that. That's a typical process.
Okay. In terms of density, there is no analysis of the density of the proposed development in the DAS, is there?
No, there's not. For the reasons I gave, density is a product of a successful design. You wouldn't spend time analysing density to the nth degree until you've gone fully through that process, and that led to the outline application that then does describe the density in both gross and net terms.
We don't have any contemporaneous sensitivity testing of different densities of development, do we?
No, you wouldn't do that. You wouldn't do sensitivity testing as part of the application.
Can we look, please, at the approach that you now adopt in your evidence? So back to your proof of evidence, paragraph 6.2.2.
Yes.
And that's on your page 26, PDF 28.
Yes.
And what you undertake is a comparative exercise between what you say a reasonable interpretation of the site allocation would be, and that is 100 dwellings at 30 dph, resulting in a net developable area of 3.33 hectares. You compare that to the net developable area of 3.35 hectares that you calculated for the proposal before the inspector. That's right, isn't it?
It is right, yes.
Yeah. Even if we assume that 100 dwellings is a minimum, yeah, I don't accept that, but just assume, so we don't have an argument about that, that's where we're coming from. Then a development that is allocated for approximately 100 dwellings at approximately 30 dph, there are a range of possible options that could result in, yes? In terms of the final output of the number and density of the development.
I think you're suggesting there's a number of ways in which you could achieve 100 units
Yeah.
at 30 dwellings per.
Yeah, yeah.
I don't actually think there are very many, because we know, in terms of looking at the layout and the constraints, we know what the northern boundary needs to be.
Sure.
We know what the western boundary needs to be. We know we need to manage and maintain the eastern boundary. We know we need internal landscape and play. I would normally agree with that, but in this situation, I'd say there's not many options, actually.
Not many options, but one option that I'll put to you, see what you think about this, 100 dwellings at 31 dph. That would have been a reasonable option that could have come from this design.
Sorry,
process.
I thought you suggested to me there were different ways of achieving 100 at 30.
Maybe that's my fault for not. Sorry, I was. Of course. Yeah, that's fine. Do you want to finish?
No, I just thought the question was, there are a number of ways in how you could achieve 100 units at 30 dph.
Yeah, I put the question poorly, so that's my fault. But let me put it slightly more clearly. Starting from your point of 100 dwellings at 30 dph, when we're thinking about that, one reasonable interpretation of that could end up with, for example, 100 dwellings at 31 dph, correct?
That might be an outcome, but again, you don't start with optioneering by picking a number of density. It's a product of design.
Sure.
And so that part of my evidence that you took me to, I was simply trying to show that the net developable area, with all reasonable interpretation, matches what the allocation assumed, which actually chimes almost precisely with Mr. Scott's evidence on the accepted change. And then I'm just exploring, well, what does that mean in density terms?
Yeah, well, and I'm just probing your exercise, because say 100 at 31 dph gives us a net developable area of 3.23 hectares, yeah? 100 dwellings at 31 dph.
Yeah.
Net developable area of that, 3.23 hectares.
3.23, yeah.
Yeah. So if we were to use that as our comparator for your exercise, 3.23 against 3.35, we end up what, an extra 1,200 square meters, yeah?
Well, that would lead you there, but that's a false premise to start with, because you're automatically toying with what is approximate, and the whole basis for my evidence in dealing with this was not to engage in the debate of approximate. Yeah. It was to take it, ruling out approximate, because if you take that scenario, well, what's approximate? It could be 34.
Right. But the reason why I put that number to you, very small change in just the dph, is to show that the comparator you've chosen is not necessarily the only reasonable comparator one could use in your exercise.
I disagree with that. For the reasons you could choose a number of scenarios.
Yeah.
I've chosen this scenario unambiguously to avoid the interpretation of approximate and the effect that might have. If I chose a different density, it would lead to a different NDA.
Yeah. And if you've chosen a different density, even, I mean, 31 dPA, dPH against 30 dPH, you're not saying that's not approximate, are you?
I'm not, no.
No, good. So using just a one different comparator, which remains approximate. So again, I'm avoiding that debate, but just using 100 at 31 dPH, that could lead to a very different output in terms of the net developable area and the difference between the two, couldn't it?
It would lead to a different output, but that's a false premise to start with, for the reasons I've explained.
Sure.
I've taken it on face value and as a baseline removed a judgment of what approximate means, which I think is the direct, pure and honest way of doing that, just as a comparator for the scheme.
And a difference of 1,200 square metres in terms of the net developable area on this site, that would be material, wouldn't it?
The difference of
1,200 square metres in terms of the net developable area on this site, that would be material, wouldn't it?
Well, it's not a premise I've assessed for the reasons I've described.
Right.
It's a false premise to assess against.
Okay. With that caveat that you don't accept my exercise, but with that caveat, it is a material difference, isn't it?
I wouldn't use the word material, no.
Okay. Condition 5 of the allocation sets a clear expectation of perimeter and internal structural landscaping, doesn't it?
It does.
And that is a policy objective which may well have an impact on the net developable area during the design process, yes?
Which part?
Well,
which part of 5?
So we go back to CD 2.1. Look at condition 5 on page 282. Focus in on the second part of that sentence, both boundary and internal structural landscape and the response to the site's topography.
Yeah, I asked that question,
Yeah.
forgive me, just to be clear. Boundary structural landscape is outside NDA.
Yes.
So the decision on where the northern boundary would go, where the eastern boundary to the orange salmon colour, those decisions affect NDA.
Yes.
Internal landscape doesn't.
Okay. I just want to understand your approach. Boundary.
Well, it's not my take. It is the industry-wide approach to understanding what net developable area is.
Internal does not. Right. Let's follow that through. Your exercise that we've looked at comes up with the 0.02 hectare differential between the two comparators that you've chosen.
Yes.
But it is also likely, using those same two comparators, that the extent of built form will be less with 100 units at 30 dPH compared to 112 at 33.4. You might not be able to say precisely, but it's likely to be less, yes?
That depends on what you mean by built form. It depends on the housing mix.
Well, very simply by built form, the size and the number of the houses.
So the built footprint of the buildings.
Yeah, and the number of the buildings.
It could reduce the aggregate built footprint,
right.
But it might not, depending on the housing mix, i.e. the example I gave earlier, and I actually think this is a really important example that if I could take a moment just to describe, because it's a consistent point. If we could go to the illustrative site layout CD 519.
Sure.
Because I don't want to be vague in answering your questions, but to try and explain why this is a difficult topic to be absolutely cast iron about. If one looks at if we're looking at the illustrative layout,
Yeah.
and we look at the block immediately to the right of the southernmost number 13 north of Kenward Road,
Yeah.
we can see a block there that has 23 units.
Yeah.
It has 8 units on the southern side of the block in 2 blocks of 4 linked units. It has 2 apartments to the north, one that's 2.5 storey and one that's 2 storey.
Sure.
That delivers 15 units.
Yeah.
If the housing mix changed at RM, and they usually do to some degree, to remove the need for apartments, 1 and 2 bed apartments, into 2-bed houses or something similar, instead of 15 units on the northern half of the block, there would at most be 8. So that in one fell swoop of a change of housing mix takes 7 units away. It might be, instead of 2-bed terraced, it might be a group of semi-detached, in which case instead of 8 it's 6. And that reduces it by 9 units. So I know I'm jumping into specifics there, but I've only done that to try and illustrate in making decisions on density and form and urbanity without considering the fluctuations of housing mix that will come at reserved matter stage. It gets to very precise answers that aren't actually able to be precise at this moment in time. So forgive me for that diversion.
You've explained that you can't be precise. That is absolutely fine. With that in mind, let's look now, topic 3, at the question of planting. Start, please, with what the examining inspector said. So go within the core dots to CD 4.1 and look, please, at paragraph 311, which you'll find on, paragraph 311, which you will find on PDF page 80, same hard copy page. And this is in the section, just to put it in context, housing allocations in larger villages, and then it specifically comes on to deal with Yaldin and our site.
So, sorry, page 80.
Page 80, paragraph 311.
Yes.
And in the middle of this, at the start of this paragraph, the inspector says it would also be necessary to incorporate amendments to identify that landscaping would be an integral aspect of the Area A site for housing, both around its boundary and within the development itself. So the view of the examining inspector there was that was a necessary component of this site, yeah?
Yes.
And it's fairly obvious that the purpose of introducing and requiring this planting around the boundary and internally is to mitigate the effects of the built development in terms of the character and appearance of the area, yes?
Yeah, I'm always sensitive to the use of the word mitigation, but in principle, yes, to help assimilate.
I'm very happy with that, to help assimilate.
Yeah.
I'm happy to use those words, to help assimilate, yeah. And this requirement, what we now see in condition 5, that wasn't in the Reg 19 plan. Let's go back and have a look at that, please. So CD 4.5. And when you're there, go please to page 215, PDF 216. And when you're on page 215, PDF 216, look at the top series of bullet points, and the 4th one down, both housing development areas will be informed by an LVIA and incorporate boundary landscaping.
Yes, I can see that.
So that's where it was before. And the change is fairly obvious, and it's what we now see before us. The word both and internal structural landscaping got added in around
yes.
boundary, and we can see that. And so if you want the reference, I'll give it to you, but the main modifications document is Appendix A to the Inspector's Examining Report, CD 4.1.2, and within that have a look at PDF 105. But
PDF 105.
Oh, well, Mr. Williams is going there anyway. So we'll do
Oh,
it.
sorry, I don't
No, it's fine. You can have a look at it. I don't mind. I was just giving the inspector the reference, but we haven't. So that was the change,
Yeah, understood.
and that was the change as between October 21 and well, the main modification consultation was in November, but the council had published this slightly earlier, September 23. You aware of that?
I'm not aware of the precise timings, no.
No, okay. And the hearings were slightly earlier in 2023. Do you know, when was the design team aware of this amendment to the condition in the then draft policy? Do you know that?
Not precisely, no. I haven't asked them that question, but I would assume that it's, if we go to page 25 of the DAS, it's clearly taken place between the vision document
Yeah.
and the further refinement that is included input by officers.
Yeah.
Precise timing of those meetings with officers relative to the status of the local plan, I'll leave that to Mr. Ross.
Well, I just want to follow that through, because do you see CD 510, the LVA? Go there, please.
Yes.
And within that, go to Appendix F. It's the very final page.
Yeah, have that.
And you know what this plan is, the Green Blue Infrastructure Plan.
Yes.
And that's an issue date November 22. Do you see that?
November 22, yes.
Yeah. So that is before the 2023 hearings, before the main mods.
Yes.
And what we see there at November 2022 is what you put before the inspector today as part of your evidence, right?
That's right, but that has come through direct engagement with officers, including site visits, the pre-app letter dated August 22 that refers to the pre-app submission in July 21. So I don't, obviously I wasn't around and involved in that process, but it's evident to me that the modelling of internal landscape has come from discussions with officers prior to August 22.
And the incorporation of that requirement into the plan didn't lead to any change from the design that was already being proposed in November 22, yes?
It didn't lead to a change because it had already factored in what the officer's view was on the site that informed policy. So I wouldn't be a failure of the pre-app process if it led to the publication of the plan and led to something totally different.
Go please back to your proof of evidence.
Yeah.
And look please at paragraph 3.2.10.
Yes.
We touched on this and I said we'd come back to it. And you say taking 100 dwellings at an average density of 30 DPH results in a net developable area of 3.33 hectares, although this should also include some internal landscape, and then you put in brackets policy element 5.
Yes.
So that is the approach you've adopted, and therefore some part of the net developable area, the salmon pink, is going to have to be internal landscaping to address that policy requirement, yeah?
Well, yes, and it's always been planned to. So I went through in chief the relationship between the parameter plan, the dotted green line that shows the principle of internal landscape, the illustrative layout that demonstrates how that could be achieved, and then I went a step further to the layout principles plan that records it in a less rigid way than the illustrative layout, which could be conditioned. So that's always been a known.
And the inspector at the outline stage now needs to be satisfied that sufficient internal landscaping can be provided, subject to the detail of the trees and everything like that,
Yeah.
to satisfy that condition. Yes,
Yes, and that's what the illustrative layout does. That is one of its roles.
Right. Well, let's have a look, please, at the parameters plan, CD 518.
Yes, I have that.
And I want to, you gave some evidence in chief on this, so I want to be really clear that I understand your position. The salmon pink area, that is the maximum extent of the residential land use, and that is fixed, yes?
Yes, there can be no residential development outside the salmon colour.
But equally, so long as the applicant constrains themselves to that salmon pink area, the council can't insist on a smaller area, can they?
A smaller area than the salmon being built.
A smaller net developable area, the council can't insist on that at the reserve matters stage.
Unless they can, if there's a technical requirement that it doesn't acceptably resolve, but the starting point is that the extent of the salmon, maybe I'm going colourblind, it looks orange to me, but the salmon...
Orange, sorry, yeah, I'm not sure where salmon came from, but orange I prefer. Let's keep it simpler, yeah.
But yes, the starting point is that that is a fixed parameter.
Got it.
And unless there's a technical requirement why residential development couldn't be acceptable in one of the corners, for example, let's say one of the root protection areas was wrong, or there's an unknown utility corridor underground that emerges through detailed site investigation, and these things do happen. So in that circumstance, there's a reason why residential couldn't sit in some part of the orange or salmon. But yes, the assumption at this stage is that that would be the limit of residential development.
And I hear what you say about the unknown pipeline or whatever, but leave all those at the side. The council can't simply say at the reserve matters stage, we'd like a bit more buffer, please, on the western side, so shrink your NDA.
Correct.
Thank you. Now, in terms of the light green area, moving to the second key, that is the land use, landscape and open space. That defines a fixed area, yes?
Yes.
And the council can insist on that being provided at the reserve matters stage, yes?
Yes.
But it follows from your previous answer 2 ago that we can't insist on any greater amount, can we?
Not of that type of landscape, no.
No. And when we look at what it includes in the key, you talked about this earlier, it includes parkland, woodland, buffer planting, for example, doesn't it?
Yes.
Help me with this. The landscaped areas referred to in the key above for the orange for the residential area, we know that you say that would include structural internal landscaping, is that right?
I missed the reference there.
Yes, of course. So if you look back above to land use residential and orange in the key on the right hand side.
The top one, sorry, or the one with the
top
green?
One, yeah.
The top one, yes.
Yeah. And it says landscaped areas. You understand that to include structural internal landscaping, yes?
Well, it allows for general landscape areas, so small pockets, tree corridors, but it allows the decision on the dotted green line and planting corridor indicative alignment and the land use, landscape and open space light dotted green line.
Yeah.
It gives that flexibility so that could move around as the RM allows within the orange area.
Okay, let me ask you about that green dashed line, please.
Yes.
There are essentially three corridors, the north, south and the 2 that branch off it, yes?
Yes.
Is the number of corridors fixed in your view?
Yes, the principle of where they are is fixed, yeah.
So the number of 3 is fixed, but the location could vary because the location is indicative, yes?
Yes, because layout and landscape as an RM is reserved, and so that can evolve and adjust.
The width, as I understand your position, your position is that the width is not fixed. That's your position, is that right?
It's not fixed in the parameter plan, no. What I've suggested in my evidence is if this is an area of concern, the layout principles plan could be condition, which is draft condition 4, that would give a commitment in that regard. Or could give commitment in that regard if it's deemed necessary.
Sure, and because the width is not fixed, we know we're going to get 3, wherever they might end up, but there's no irreducible minimum in terms of how big they're going to be, is there?
That's not a fixed parameter to set that, no. But as I said before, the illustrative layout and the layout principles plan gives a very strong indication of what that envisages, and it's a corridor, as I've scaled, of between 9 and 10 metres.
And in terms of what could be brought forward in terms of size, how big these are going to be, the only indication which the inspector has is the one that you just referred to, which is the indicative plan, yes?
The illustrative layout
sorry,
and
illustrative
the
plan.
layout principles plan, so those two.
Yeah, but you don't present any evidence, for example, to say that at the reserve matter stage those corridors would be materially larger, do you?
Materially larger than?
Than what is shown in the illustrative plan.
No, but I don't think it needs to. But no, I haven't said that because I don't see that as a necessary point. I mean, this is very common, and in my experience of going into RMs having this discussion, an authority will say you need to provide this. So if there's concern over the level of fixture, as I said in chief, I don't think there should be, but if there is, conditioning the layout principles plan will just deal with that point.
Sure. Now, when you're assessing compliance with condition 5 and the requirement for internal landscaping, you've therefore based your judgment of acceptability on those 3 corridors in an amount as shown on the illustrative plan, yes? That's the basis of your judgment.
Almost right, yeah. I have assumed that they are all delivered in accordance with the description of the parameter plan, as illustrated on the illustrative layout, in accordance with the principles of the layout principle plan.
You've not assumed that any greater amount of internal...
I haven't.
Structural landscape.
I recognise it's a fluid point because it will evolve through the landscape RM.
Yeah, sure.
But I've assumed that the correct interpretation of how it will come forward is as illustrated in the illustrative layout and the layout principles plan.
And is that the same approach that was adopted in the LVA?
I've not asked that direct question, but a reasonable assumption would be, of course it was, because that's it's shown in the mitigation plan that's Appendix F to the LVA.
Can we look, please, at the LVA CD 510? And can I ask you to go, we need to go into the appendices, please. Appendix C.
Appendix C?
Yeah, and if you want the electronic page number, it's PDF 95.
Sorry, PDF?
95. And we're dealing with receptor G, users of Hampstead.
Yes, I have that.
Lane. Yeah. Now, in terms of this, there are 2 judgments being made. The first is about vehicles and cycles. That's Roman numeral 1. The second is about pedestrians, yes?
Correct.
On the second, susceptibility is assessed as high medium. That's the 3rd column, yeah?
Yes.
4th column, value medium, yeah?
Yes.
5th column, sensitivity. Join the judgments together, high medium, yeah?
Correct.
There is no more sensitive receptor identified in the LVA, is there?
Not more sensitive. There's some of equal sensitivity, but yes, there's no.
Yeah.
Not aware of more.
And in terms of the scale of effect, so 4 more columns over. Construction medium low, completion low, and year 15 low negligible, yes?
Yes.
And again, focusing in at completion, an effect that is judged as being low, apart from at the very entrance to the site, that is the greatest effect that is assessed by the LVA, isn't it? Leave aside viewpoints 1 and 2 at the start of the site. Do you agree?
Receptor C is the same.
It's the same, yeah, fair enough. But no, nothing greater.
Receptor A is greater.
Yeah, but I said leave aside the ones at the site.
Okay, beg your pardon. Yes, that's correct.
Great. Now, in respect of the effect, we work this through, we get 3 columns, the final 3 columns. The anti-penultimate one is overall effect at construction phase. Leave that to one side. We get completion, minor adverse, yeah?
Yes.
And then we get year 15, minor adverse, yes?
Yes.
So the assessment here is that the effect is the same at year, essentially completion and year 15, yeah?
Correct.
Now, when we look at the explanation, the commentary, we get the description of what's going to happen, where Hampstead Lane is, we get a description of the views, we get told about vehicular users will have fleeting views, pedestrian users following the route of the Medway Valley Water considered to have views focused on the landscape. Then in terms of the effects, this is what we're told. New dwellings will be visible in the context of the more prominent polytunnels and caravans within the views. New landscaping within the street corridors will help break up the massing of the new built form.
Yes.
Now, that last point, the new landscaping within the street corridors, that's going to be provided, but the judgment of the LVA is even when it's provided, it doesn't have any mitigating effect on that particular receptor, correct?
That's correct. And that's not uncommon because there's quite firm boundaries in judgments and steps down. And often, if it was an LVIA, I think it would be more descriptive to explain what changes within the views and explain why it doesn't step down to a different category. But
so in terms of how this receptor appreciates the assimilation into the landscape, and bearing in mind that the purpose of the corridors is to do that, as we said, to assimilate, the LVA is not detecting any material benefit from providing the 3 corridors, is it?
It doesn't say that in that judgment.
No,
but the next step down is negligible. So what in effect it's saying is that even with the success for that internal landscape, you will still see some roof lines, etc. That means I can't come to a negligible judgment. So I don't see that as being unreasonable, and that shouldn't be interpreted as the mitigation not having an effect, a beneficial effect.
Well, I'm going to put it to you that the LVA does not identify that mitigation as having such a beneficial effect, does it? A materially beneficial effect, not identified. Correct?
No, it doesn't, but that's not uncommon in LVAs or LVIAs. It's got to pass a certain threshold so that success of a mitigation strategy, if you can still see a notable degree of built form even through the success of that screening, you can't conclude that it's negligible, which is the only step down from minor.
Well, let's be fair. You're right that that's the absolute step, but if you look at just the example above, G, Roman numeral 1, vehicle cycles, that does do a half step, doesn't it?
It does for K, yeah.
No, for G, just immediately above. So we were looking at minor, adverse,
Yeah.
If you look at vehicle cycle, that goes minor, adverse, negligible. So we don't even get half a step here, do we?
No, we don't. But as I said, that should not be connected to the successful failing of the internal landscape.
So what other measure in the LVA is there then? For the success of the internal landscape. If it's not these judgments, what is the measure in the LVA for the success of the internal landscape?
Well, the success of the internal landscape is that it will grow above the roofs. It will, after 15 years, it will have a mitigating effect on the visibility, the amount of visibility of roof structure in some of those views, and that would be a mitigating effect. But you would still see some.
Sure,
and you would, the point being, you'd still see some regardless of whether it was 100 units or 112.
And you understand that Mr. Kirkpatrick, his views he's expressed is he doesn't think there's enough. He doesn't think what we have at the minute is adequate. And you've heard him explain that. I'm going to put to you that the LVA, in the judgments it's reaching here, is confirming that because it's not noticing a material difference. That's right, isn't it?
I don't think that's right. I mean, I think if the success of internal landscape was whether in views of around a kilometre distance was to be less than minor, then that's such a high bar that would rule out most development sites. The success of internal landscape is far more nuanced than that.
Can you stay with this Appendix C, but move back, if I can ask you to go back, please, to viewpoint C, or receptor C, I apologise, receptor C.
Yes.
This is dealing with the sorry, I've given you the wrong reference. It's receptor A. I'm sorry, it's Appendix C, receptor A. Apologies. So just go back one more page, please.
Yeah.
Receptor A. This is dealing with users of Kenward Road, viewpoints 1 and 2, and we get parcel north and parcel south again. And this is where we get that high scale of effect, and then medium, low at completion. We've talked about that, but just work through again. Overall effect on completion, minor adverse, no change year 15. Yeah.
Yes.
So the buffer planting, the setback, and any internal landscaping, so what is referred to, if you look at the description notes, final paragraph, for completion the housing within the northern parcel will be visible from the western approach into Yalden along Kenward Road in the context of the hedgerow and polytunnels to the sides of the road. The new access arrangement will include new landscaping. Views into the site will also include a new area of public open space which will help soften the appearance of new dwellings within the northern site parcel. So that landscaping that's referred to, the public open space that is referred to, that setback, not assessed as having a material difference between completion and year 15 for the northern parcel, correct?
That's correct. But again, I think this has been taken very formulaically. When you look at receptor A, tested through representative viewpoints 1 and 2, they're naturally ground level viewpoints of people on Kenward Road.
Yeah. And
at constructional completion stage, i.e. all the entrance open space is implemented, I wouldn't automatically assume at that level, i.e. the physical height of the receptor on the edge of the site, I wouldn't automatically accept that there would be a significant difference through the establishment growth. The growth and establishment mitigation is much more likely to have an effect on more distant views.
Okay. And if I put it to you, I've asked you about the most sensitive view. This is the view with the greatest scale of change.
Yes.
Mr. Kirkpatrick's expressed his concern about the adequacy of the setback and the proposal here. The LVA, in maintaining the same judgment on effect, is reaching a consistent view of Mr. Kirkpatrick that actually this is not going to materially change. That's right, isn't it? It's consistent with his evidence, yes?
I would not draw the complete parallel between the two.
Okay.
The success of the mitigation is more than seeing a step change between completion and 15 years. I mean, the 15 years is the growth to maturity. It's not the success of the mitigation, because the mitigation is in from day one. Yeah. So it's the effect of growth that would lead to a difference of judgment between completion and 15.
Fine. Now, I'll make submissions on that. Okay, fine. Topic 4. So I see where we are with the time. We've done an hour. I'm happily, thank you, Mr. Williams, making very good progress. So I'm not going to be more than an hour now. So if you want to take an afternoon break now, then yes, it would be a good moment to do so. Thank you.
Fine, let's have a thank you. If we can now resume the inquiry. Mr. Henderson, you thought you had about an hour left?
Yes, I hope to get done within an hour.
Thank you.
I've heeded your comments. Okay, topic 4, the parameter plan and the areas shown there. As I understand your evidence in chief, you consider, looking at the parameter plan 5.18, that the net developable area could move closer to the eastern boundary, but you disagree with Mr. Kirkpatrick as to what extent it could move closer. Is that right?
Sorry, what part of my evidence?
So CD 518.
CD 518.
518.
Oh, yes, sorry, yes.
The parameters plan. As I understand your evidence in chief today, you accept that the orange net development area could move further east, but you disagree with Mr. Kirkpatrick as to how far that would be possible, yes?
Not quite. I said it's possible to... The point I was essentially making was that Mr. Kirkpatrick was suggesting move the orange area to push up to the root protection area of the trees. And so I've overlaid the root protection area of the trees and seen that there is a slither, it's quite a thin slither and narrower than he suggested, between the orange area and the RPA. I'm certainly not advocating that you should do that. Technically you could, on the basis of it's not conflicting with the RPA, but you've still got to provide sufficient space to manage the hedge, manage the drainage ditch, and I would be, I gave evidence in chief, I would be concerned about pushing housing closer simply because of the robustness of that hedge. The overshading is likely to lead to pressures on residents, and we know from experience where that might go.
But it's not necessarily houses, you're simply moving the residential area closer. How you lay that out to deal with those issues is for reserved matters. You could tackle those later down the line, yeah?
Yeah, I mean, you could have an access lane at the edge of the site. It's not a very efficient use of land, but you could do that.
Yeah. And so we understand what we're talking about here, please. CD 5.2, and within that go please to page 22.
Yeah.
And you should have the tree retention plan, do you?
Yes.
Yeah, and the root protection area for the hedge is that which is outlined in blue, isn't it?
Correct.
So subject to your caveats about having to design a lane or in to maintain, so the inspector could see it visually, we could move that residential area up to the blue line on the plan, yeah?
It would be physically possible to it, but I do not agree that that is a good idea and sensible. I wouldn't support it as a change, no. Technically possible in regard to the RPA. I don't know with detail about access to the drainage ditch.
Fine, well, if you don't know, you can't help, that's fine. Now, in terms of the assimilation of built form on the site, the built form on the eastern side of the development is not the priority, is it? Is not the priority, is it?
In terms of
assimilating into the landscape. What we're really concerned about is the north and the west, which is why that's where the greatest buffer is, yeah?
Well, the north and west are the outer countryside edges.
Yeah.
So naturally that's where you would put your structural landscape elements to try and assimilate in views from those directions.
Yeah. And therefore redistributing land from that eastern edge to those areas would assist and would enhance the assimilation, yes?
Well, I don't agree with that. I mean, as I gave in chief, the idea that you take a couple of metres from the east and move it to the west and suddenly that is a perceptual change in the performance of mitigation, I don't agree with. I think the real world interpretation of that from these views that we've discussed, whether it's from Kenward Road or further to the southwest, I don't think that would manifest in a perceptual change.
Okay, so it's about the perception, okay.
Well, simply, the point I was making was that you've got an existing mature hedge on the west, you've got a robust tree planting corridor, 8 metres or so wide. A little bit more doesn't take it to the next level in terms of mitigation performance.
Now, the exercise that you did, your comparative exercise, came up with the 200 square metre figure. That 200 square metres, if freed up, would allow additional tree planting within the site, wouldn't it?
167 square metres, let's say, to be
Sure.
precise.
But, I just use your proof, but yeah, okay, 167.
Yeah, it's a tiny small area that you might put an extra couple of trees. Yeah.
Yeah, sure. If you had a substantially larger area available, 1,200 square metres, that would also allow additional tree planting, wouldn't it?
Potentially, yeah, depending
And
where you
that
put
would
it.
materially assist with assimilation, wouldn't it?
Possibly. I mean, you'd have to model it and test, but possibly.
Yeah, sure. Okay. Now, in terms of that modelling and testing, all that the inspector has before him is what is proposed, isn't it, in terms of the modelling?
Yes, because it's in the final LVA. Yeah.
You haven't presented different photo montages saying, look, we had a look at this and we thought it wasn't great for these reasons, so we went with this. We don't have any sort of audit trail like that, do we?
Well, we know they were done because they were discussed with the authority and they're in the pre-app letter response.
Sure.
So as a process, it's recorded. I've had the discussion, as I say, with the team and understand how that's evolved.
Have you actually seen them, Mr. Williams?
No, I haven't.
Right. So when you say that other scenarios were modelled and were considered to be inferior, not as good, or however you want to describe it, that is not your judgment, that is somebody else's judgment which you haven't been able to check, yeah?
Yes, my role is to understand, in that specific regard, was to understand how the LVA has shaped the process leading to the outline application.
Yeah.
And the discussion I had with the team was that they modelled different options and agreed that the north-south route in particular was the most effective assimilation. So that decision was changed, that decision was made, it was discussed with officers, and the scheme evolved further from there.
It's fair to say that if the inspector can't see it himself, and you can't see it, really that process that you've described is a matter to which only limited weight can be afforded, isn't it?
No, I disagree entirely. I mean, it's a process and it's a requirement actually of assessors to not chart that process in the LVA. They have to assess the product, the outcome, because a lot of this is about avoiding confusion of what you're assessing. And that's where the dash shows that story. But as I say, you only have to go to the pre-app letter in the core documents to see that they were prepared. And the fact of the matter is the test here is against the site allocation requirement 5 and 15. Was an LVA carried out that influenced the form? Yes, it was. It's evidenced. It's in the pre-app letter. It's in the DAS. So as far as my role in terms of understanding that, that's as far as I need to go. And I think that's as far as the inspector needs to go.
Okay, let's go to the LVA now, please, with that in mind. CD 510 again, and can I ask you to go to PDF page 91, please?
Yeah.
Yeah, no, well, I'll just hold fire whilst Mr. Tucker sorts out. That's fine. Now, on page 91, we have Appendix B dealing with landscape effects, not visual effects, but landscape effects. In respect of the site and its immediate context, and the northern part, Site A, that assesses an overall effect on completion as moderate adverse, and then it assesses an effect at year 15 as moderate / minor adverse, yeah?
Correct.
And the reason it does so is because, as it says in I think it's the 5th paragraph, new landscape proposals will result in new native planting, which will enhance the boundary features and increase biodiversity. That's the reason for the shift, yeah?
Correct.
So if additional tree planting could be realised, that is something which would assist this mitigation, yes?
If additional tree planting was proposed?
No, if it could be secured, additional tree planting over and above what has been assumed,
Yes.
then that is something which would enhance this mitigation, yes?
Possibly, but you'd have to look at the amounts and whether that was proportionate to an improvement. As we said before, you can increase an area, but that doesn't necessarily mean a step change in your assessment.
Sure. So your point about perceptibility, got it. 2 more pages further forward, please. CD 510, PDF page 93. Viewpoint C.
Yes.
This is an example. Sorry, not for C. Bear with me. B, apologies. B, on the same page, B.
Yes.
There is again a shift from year 0 moderate minor adverse to minor adverse negligible.
Yes.
And the reason for that we see in the the antepenultimate paragraph of the test, from completion of partial or glimpse views of the upper sections of the new house in the northern parcel will be visible. Planting within the site will soften these to a degree, and more so over time. They will have limited screening capability. Again, if more trees could be planted, that is a matter which would assist the mitigating effect noted there, isn't it?
Yes, I'm just trying to read that to understand.
Sure, take your time.
The how Site A and Site B affects that. But bear with me a second.
Yeah.
Yeah, it's not. The assessment's not explicit as to the change from completion to 15 years. The degree to which the mitigation on Site A and the enhancement of Site B contribute towards that shift in assessment.
Right.
But the same, I take the point,
answer.
the same principle is it's possible, but it's subject to the quantum, and as I described on the western edge relative to Mr. Kirkpatrick's evidence, small increments of additional planting does not have a step change in the perceptual mitigation effect.
Right. Topic 5, process. The only LVA before the inquiry is that which we're looking at, CD 510, yes?
Yes.
That's dated 2023, October 2023, and it's the one that accompanied the application, yes?
Correct.
Go please to PDF page 5, paragraph 1.1.
Yes.
Second sentence, we get told what the purpose of the document is. The purpose of this LVA study is to provide an assessment of the likely landscape and visual effects of the proposed development.
Correct.
Of course, I'm sorry, Mr. Tuckett. Yes, PDF page 5. No, it's my mistake. I'm sure. Paragraph 1.1 is the second sentence I just read out. And that assessment is underpinned by the parameters plan, which is referred to in the next sentence, yeah?
Yes. And the Appendix F of the document.
And the documents in the appendix, is that?
The Appendix F to the document is the
Yes.
landscape. Yeah.
Understood, thank you. And the assessment is, given the way it's set up, a retrospective exercise in considering the proposed development as it's presented on the relevant plans and commenting on its effects, yes?
I wouldn't use the retrospective word, but it is an assessment of effects. I mean, I touched on this in evidence that the LVA process, from the time you get instructed as a landscape architect to work on a project like this, you're influencing and shaping, you're analysing baseline, you're commenting, you're briefing. There's very clear guidance that the product of that, it's not the only product, but the product as an LVA has a limited scope to assess, and in fact its sole responsibility is to assess the landscape visual effects of the scheme that's then fixed. So that contribution to evolution doesn't take place in the LVA, or at least not to a very significant degree. It describes the mitigation process, which is why, and I mentioned this in chief, which is why that process is dropped into the DAS, because the DAS is a sort of explanatory persuasion tool to explain the process, and the LVA is not that. It has to be neutral and objective.
In an LVIA context,
Yes.
it is and can be part of the role of such documents to consider reasonable alternatives, isn't it?
Yeah, but that's different to storytelling. And in an LVIA, it's not the LVIA chapter that does that. It's the chapter that separates the LVIA that looks at the reasonable options that were identified for all of the chapters in the S before they assessed what was being applied for. So it's not the same tool as describing the process and showing how you shape the scheme.
But what that does, it lays down an audit trail for, we looked at these reasonable alternatives and we discounted them for whatever reason, yeah?
Yeah, but in that example that you've just given, that would not have given you the answer to how the LVA has shaped the scheme. The answer to that is in the DAS, where the references that I gave in chief are made. No. And that's common, and that's quite right and correct.
Stick with the LVA. Go forward, please, to paragraph 5.1 on PDF 41.
PDF
41. Thank you. And this is the section that you quote in your proof.
Yeah.
And in terms of what this document tells us, if we look at paragraph 5.1, it tells us the development proposals are described in the DAS and other information accompanying the planning application, including the parameters plan and landscape strategy plan, see Appendix F.
Yes.
That is a description of what is proposed. We'll come on to the DAS. Then it goes on, it says the existing landscape resource and visual receptors and amenity of the site have been considered by the planning and design process and have informed the resultant scheme. So we've got the statement that that's been done.
Yes.
But in terms of backing that up, as I understand your earlier answer, it's not in this document. We've got to look at the DAS, yeah?
Yes, and I went through that to explain that process of where it is in the DAS.
That's fine. I just want to chase it down. Now,
and as I've said, sorry to add to that, that is the right way of doing it. If that optioneering was done in the LVA, it starts to break the boundary that's set out in the guidance in Clivia and recent Landscape Institute guidance that reaffirms this point, that LVAs and LVIAs should not and must not be seen as tools of persuasion. So that's why these documents don't tend to get into that explanation, rationale and options. That sits in the DAS to keep that neutrality or perception of neutrality of the LVAs.
Now, if we look at the next paragraph, which is one that you also quote in your proof, this is dealing with the landscape design and green infrastructure objectives. Yes, that's the subtitle?
Yes.
The introductory text says the key objectives of the landscape proposals for the scheme include the following, and then it cross-references back to the DAS.
Yes.
But just to be very clear, what is being listed here are the landscaping which is proposed. It is not, for the reasons you've given an audit of how we got there, is it?
Sorry, could you repeat?
Yeah, this is just giving us the output.
Yes, it's saying this is the
It's
design.
not giving us the audit, yeah?
Correct.
Right.
It's not the procedural point. It does touch on slightly more less specific product outcomes in the next page, where it talks a little bit more about why certain things have been done. But yes, it's not the audit trail of how it evolved and why it evolved.
Got it. Now, in terms of this, let's put ourselves back in the planning context. So CD 2.1, please, the local plan. And back to the allocation, page 282, but I'd like you to look, please, at condition 15, which is on 283.
15, yeah.
Yeah. Now, in your proof, in Mr. Roster's proof, in the planning statement, nobody's ever raised an issue about being able to comply with this. Your client's position is, we can comply with it, and we have, yeah?
Correct.
Okay. The development proposal shall be designed to take into account the results of a landscape and visual impact assessment undertaken in accordance with the principles of guidance in place at the time. The process that this envisages is that there is an assessment
Correct.
that produces results,
Yes.
and that is taken into account in the design, yeah?
Correct.
Sequentially in that way, yeah?
Sorry?
Sequentially in that way.
That's how it anticipates it. That's not aligned actually with the practical process that I've set out, that one can do it, because you cannot do that in the output of an LVIA or LVIA process. It's in the process that leads up to that final report. But I agree, that's what it says.
Right. That's why I asked you the earlier question. So you don't think, so contrary to the answer you just gave to me before, you don't think it's possible to comply with this on its terms?
Well, it's semantics. So I agree, landscape and visual impact assessment is not written by a landscape architect that does this work. They would have said a landscape and visual impact assessment process, knowing that the iteration that this is describing, i.e., it needs to shape, the proposals need to be the product of or take account of, that actually happens in the process. It doesn't have, you don't write an LVIA and get to the end and say you need to do this, this and this, and then hand it to a design team to say, oh right, I hadn't thought of that, I'll design it this way. That's just not practically how it works at all. But I don't take issue with that, because I read it on common language that when it says landscape and visual impact assessment, clearly it means the process from when the landscape architect is commissioned to do that piece of work, all the way through to the outcome of the report.
Yeah, right. Now, let's have a look, please, at the DAS. That's where you've led us to. So CD 5.4.
Yeah.
In terms of what this tells us about the assessment that was undertaken, we've got on PDF page 22, internal page 20, the landscape analysis.
Yes.
And this, just so we're cited, this is in chapter 2, which deals with, it's titled assessment.
So I missed that last piece.
This chapter is titled assessment, yeah?
Yes.
And that's it in terms of a baseline assessment in the DAS, right?
Baseline assessment and landscape.
Yeah.
Yeah, I wouldn't expect more than that. That's what the LVIA is for, LVA.
Now, when we read on, so same document, move forward, PDF page 40, internal 38.
Yes.
We get the introduction.
Yes.
And this actually is the only reference, isn't it, to the LVIA. It says, or the LVA, sorry, for the fuller details related to landscape proposals, please refer to the various reports by FPCR submitted as part of the planning application, in particular the landscape and visual assessment.
Yes, but you've skipped across all the scheme iteration where all the landscape and visual guidance to the layout has taken place.
Right. Well, by that you mean the previous section. But let's just come back to this. But this on its face is sending us back to the LVA, isn't it?
this is now talking about landscape design.
Yeah.
So that you've jumped from process to product.
Okay. So let's look then at the part that you want to look at. So go back, please, to page 24.
Yeah, so
This
we're
is
going to...
PDF, and this is PDF 26.
Yeah.
And the initial options. And when we look down that bullet point list, none of them refer to the outputs of the assessment, do they?
No, but no, they don't. But you're misunderstanding the process.
But of any assessment, of a baseline, they don't say we've had the landscape and visual team in, and they've given us this advice, and therefore we've done X in response.
Well, it does actually, yeah.
Well, which bit says that?
Well, the end of the first paragraph says the team investigated potential design strategies, and the team was the wider team that I spoke to, which involved the architect and the landscape architect. And there's some misunderstanding of the assessment process going on here, in that you can summarise it as you do a baseline exercise. As a landscape architect, you get to understand the site, you get to understand the context, you map it, you walk it, you get a feel for it, you get a feel for what's important. Then you get involved in design iteration. No, don't do that. Let's have a bit more there. Let's model that. Let's test that. That eventually leads to a frozen scheme.
Yeah.
You tell the story in the DAS from that early stage to the frozen scheme. The LVA picks up the frozen scheme and assesses it. So all of this section of the DAS is the team contributing, including the landscape architect. And this is how the LVA process has shaped the scheme.
Sure. But what I take everything you say at face value, but what this doesn't identify is an output from the baseline, from the landscape architect, doing his walk round, as you've said, and collecting his thoughts, and a product, does it?
It doesn't work like that. It just does not work like that. The design process doesn't... You're misinterpreting what happens up and down the country on a week-by-week basis on successful schemes. The landscape architect does not write a report and give it to the architect, say, there you go, do that. It's a collaborative approach that's not... It's not hanging on a report. A report happens at the end.
Sure. I'm not saying it has to be a report, but somebody's had to give some input to have some effect, yeah? You might have done it in a meeting, you might have done it in an email. There's got to be some input and an effect, yeah?
That's right, and I described how that has happened.
Sure, but you've described it in general terms, I get that, and you say that's happened here, but in terms of showing where that's evidence, where is the input identified, and where's the output from that?
Well, I went through that in chief.
Not the LVA, but show me, if we start at the start here, the design evolution.
Okay, so design evolution...
Which bits on this page show the audit trail?
The team investigated. So the team, and I know who the team were, that's the architect, the landscape architect, including ARB, ecology, etc. The team investigated, and there was discussions over the content of these drawings. So what you see in landscape terms on these drawings has been shaped by the landscape architect. It's not in the LVA for the reasons I've explained. I could go on, but I'd be repeating myself. Refining the proposals, the refinement focused on the following principles. This is on page 25. Increasing the landscape boundary area within the highest northern part of the site. Who do we think advised that? Do you think the architect decided that would be a good idea? No, the landscape architect decided that was a good idea. I'll stop there, but...
What you're asking us to do is to infer that that's what happened, isn't it?
No, this is what happens in a DAS and an LVA. Trying to be forensic about where's every decision been taken from the landscape architect, that doesn't happen.
But the policy and the condition that we looked at in the policy needs an output, and it needs that to be taken into account. I'm going to put to you very simply that what you're asking us to do is to infer from this that happened without showing an audit trail. It doesn't have to be in an LVA report, any sort of audit trail. That's not something you can show. You're just simply asking us to infer from this design story, yes?
I'm not asking, no, that's wrong. I'm not asking you to infer, I'm asking you to read what it says, what it shows, and understand the processes that took place behind what it's saying and showing. I've described the landscape LVA or LVIA process, and that is not a rhetorical or an explanatory document. I've explained that a few times.
Now, move forward, please, to page 39, PDF 41. This is the Appendix F document that you've referred to in your proof.
41,
PDF,
PDF 41,
PDF
sorry.
41, yeah.
Yeah.
And this is where we get the 12 points. And you rely on this also to show the process, yes?
So I didn't quite hear that. This is the end. So this is what happens at the end of the process, which is why it's appended to the LVA. Yeah.
Provides recreation benefits for users. This, yes, bullet point 1 on the left-hand side at the top in the green box. Are you there? Yeah. Sorry, maybe I was unclear. This is dealing with how that is going to be planted and the effect of that planting rather than any question of layout or form, yes?
This is a description of the space that has been shaped through that process. So this is the end of the process. This is the frozen scheme. Yeah. So it's just describing the content of the landscape spaces. It's not explaining why it's there or what it's seeking to achieve, because that has happened prior to the fix of the scheme.
Now the second bullet point down about play spaces, that does deal with layout, doesn't it? Because it explains where they've been located.
Yes.
The third one down, that is dealing with the enhancements through planting to the hedgerows. It's not dealing with layout or form, is it?
Well, apart from the reasons that I've said, it's the decisions on layout and form have been made prior to this plan. It's a point I keep making. This is at the end of the process, and it's describing the landscape content. It's not retrospectively explaining how it shaped that process.
And if I was to ask you the same questions about 4, 5, and 6, again, I assume I'm going to get the same answer. They're not dealing with layout and form. They're dealing with planting, but you say that's because it's the end of the process, yes?
Yes. So, for example, the entrance space. This is not describing the entrance space is here, it's this size, it's this setback to enable development to allow an open space at the entrance of the village. It's not saying that. That decision's taken place prior to. That's the process. Now what it's saying is, well, there's trees here to do this and so on. So it's talking about the content of that space, not the explanation of why it's there, why it's a certain size.
Now, your proof of evidence, in fact, I think we can, yeah, your proof of evidence, please, on page 16, PDF 18.
Yes.
And this is where you deal with the process points. We've looked at those paragraphs in the LVA that you cite, but go forward please to 5.2.4 on page 17.
Yeah.
And what you say that the LVA has shaped the scheme, including key elements, and you list the northern buffer, the western boundary, and the internal landscape treatment. And you do so by reference to the plan which follows, yes?
Yeah.
In set 5A and 5B.
Yes.
And then if we look at 5B, the green-blue infrastructure principles, they are all the ones that we've just been looking at 1 through to 6, aren't they?
Yes.
But what they show, as we've agreed, is an output, and with the exception of place space, those are outputs which don't deal with layout and form. That's right, isn't it?
Well, they are the products. They need to be read alongside the process to fully understand the role of the LVA process in shaping layout and form.
Sure. Well, the reason I'm taking you back is this: your 5.2, you kick off with the LVA, yeah.
Yeah.
And we've looked at those paragraphs, and I've asked you questions about those paragraphs, and you've told me, look, the LVA is not the audit trail. You've got to go to the DAS. And then we've looked at, so we leave the LVA to one side. So then we go to your 5.24, and then you tell us, well, you've got to look at this plan.
Yes.
And I've taken you to the plan, and I've asked you about the plan, and you said to me, well, no, that's the outputs.
Yeah.
That's not the audit. And then that's the end of your analysis in this chapter, isn't it? That's the material that you've pointed to in your proof to illustrate the point. And now you want us to look at something else. Is that right?
Well, you have to read this. Yes, I am saying now you have to read it alongside the DAS to fully understand the process.
Yeah.
This was focused explicitly on the LVA, but as I've explained in chief, the process needs to look at the DAS to understand precisely how that's been shaped, and that's a response to the council's evidence on the LVA.
And then to round this off, if we go back to the application policy, please, CD 2.1.
Yeah.
Look at page 282. And look at paragraph 5. And we're dealing now with the first part of this.
Sorry,
Of course, I went too quickly. It's CD 2.1, page 282 is the allocation. I think you might have it.
282, yeah, beg your pardon, I'm there.
No, it's fine. Look at condition 5.
Yeah.
Ignore the second part, which we already talked about. The first part, the layout and form of the housing element shall be informed by an LVIA. Substitute LVA because it's not a EIA case. The material that you pointed us to in your proof, the LVA and plan, that is not material that deals with the layout and the form of the housing element, is it?
That's the product of that LVA process. And I went through the internal landscape, the structural landscape, that's all part of that process that's charted in the DAS.
And this goes back to your point that you say you can infer that from the DAS, yeah?
It's not inferring. You can read the words and look at the images. You can cross-refer to the pre-app letter that tells you what was submitted.
Right. Topic 6, please, the LVIA. I want to look at how this has studied the baseline first of all. So CD 510, which is the LVA, and the baseline description is in chapter 4. And can we just focus in on the borough landscape character assessment? And as I understand it, you think that they are the most relevant, yes?
Yes.
Thank you. And they start, if we start with LCA 38, this is dealt with on PDF 28, sorry, internal 26.
Yes.
And at 415, what this assessor has done, he or she has copied and pasted the location and the key characteristics from the document for LCA 38, haven't they?
Yes.
And if we move forward to paragraph 419.
419.
Yeah, 419 on PDF 30.
Yes.
The Medway Valley Yaldin LCA. This is LCA 53 again. The assessor has copy and pasted in from the master document, haven't they?
They have, yeah.
And then the same point at the bottom of the page and over the page for paragraph 422 for the Linton Green Sand Ridge LCA 34, yeah?
Yeah.
Fine. By copying and pasting in this way, what we don't have in this baseline section is an identification of, out of these documents, what are the key characteristics that apply here? That process hasn't been documented, has it?
Not in that section, but it does go on to talk about site and immediate context within baseline to follow.
And have you got your copy of Olivia, please?
Yes.
So, obviously I've got my copy separately, but it's definitely in the core docs now. And Mr. Scott can give you the reference, I hope. Thank you very much. It was a late edition, sir, but it is there. I was to touch was going to whip out its hard copy, but I thought you were going to whip out your hard copy. No. So, within that, can you go please to paragraph 5.33 on page 86?
533.
Yeah, page 86. Have you got it?
Yes.
Yeah. This is under the subtitle reported on the, so you don't have it? No. Right, this is under the subtitle reporting on the baseline situation. And it says, when reviewing of existing assessments and any new surveys are complete and evidence about landscape values being assembled, a landscape baseline report should be prepared. It should be a clear, well-structured, accessible report supported by illustrations where necessary and should. And then the second bullet point, identify and describe the individual elements and aesthetic and perceptual aspects of the landscape, particularly emphasising those that are key characteristics contributing to the distinctive character of the landscape. And if we look down to paragraph 5.34, same page, once the baseline information about the landscape is available, this can be combined with understanding the details of the proposed change or development that is to be introduced into the landscape to identify and describe the landscape effects. The first step is to identify the components of the landscape that are likely to be affected by the scheme, often referred to as the landscape receptors, such as overall character and key characteristics. So in terms of, firstly, the baseline reporting, the baseline report here hasn't drawn out those key characteristics, has it?
Yes, it has, and I dealt with this in my evidence, in part on page 21, but when you look at the DAS...
We're in the LVA though, not the DAS.
Sorry, beg your pardon, LVA.
Sure, okay.
When you look at the section you've just taken me to, which is effectively identifying the landscape receptors and drawing out the key elements that relate to the site, that's not the end point. So the LVA then goes on to describe the designations. There's a number of paragraphs on that.
Yeah.
It describes the topography.
Yeah.
Describes in more detail the site and the immediate context.
Yeah.
It then talks about public rights of way. Then talks about landscape value, which is still part of the baseline exercise to understand the designations, the heritage, the cultural heritage, the landscape condition, associate distinctiveness, value, recreational perception, etc. Functional elements, that's all part of that landscape baseline.
But what Olivia is asking for, and frankly what one ordinarily sees, is a working through of the LCAs and an assessment against those LCA descriptions and the key characteristics there. Well, what applies here? And that's not been done, has it?
The connection has not been drawn between the baseline and the description, but the work on understanding the landscape elements have. And I deal with this on page 21 of my proof. I say there's no explicit evaluation of the site's representativeness of the host character types. Yeah. And then I go on to explain how it addresses those key characteristics in the text of the LVA.
I've read what you said, and because your answer is not to say it's been done, it's to say, well, if you look at the end, we might have gone awry earlier on, but you think it's okay at the end. That's your approach.
No, I'm not saying that. I'm saying it's clearly considered the elements that are identified in the landscape character assessment. It just hasn't done it explicitly. It hasn't said these are the elements within that landscape character you can see. But you have to be careful with Clivio. It's all about being proportionate, and this is one field.
It's also about being transparent, though, isn't it, Mr. Williams?
Well, yes, but I don't think there's anything wrong that's being done. Let me follow through. There's one field in terms of the elements where the development sits. Of all the landscape elements and how it can relate to that wider area, there are extreme limitations. It's got hedgerows and it's got polytunnels. So I wouldn't expect a big section of text on this, because the answer to the so what is it's got hedgerows and it's got polytunnels.
Yeah, but in terms of transparent judgment that we can follow through, you say we have to go to the end.
No, I'm not saying that.
And we have to infer. Yeah.
I'm not saying going to the end. I'm not saying that at all.
Stay with the LVA, please. Go to paragraph 4.62, please, which is on PDF 36.
Yeah.
Now, what we get at 462 is the cumulative judgment on value, one of a medium value landscape. Yeah.
Yes.
Now, to get to sensitivity, we need to consider two judgments. The first is this one, value, yes?
Yeah.
And the second is susceptibility, yeah?
Correct.
Now, in terms of susceptibility, that's not dealt with here in this baseline section, is it?
No.
We do know about susceptibility in Appendix B, so can I invite you to go there, please?
Yes.
PDF page 91, for example. And if we look there, dealing with the site itself and its immediate context, the judgment is made of a medium susceptibility, yeah?
Correct.
And that gives us an output in terms of overall sensitivity of medium.
Yes.
First thing to say is the reasons for reaching that judgment on a medium susceptibility, they're not set out, are they?
Not explicitly, no.
No. Now, if we follow that through, the output, well, let's just pause there, sorry. Going back to Clivio, paragraph 328.
328?
Yeah, 328, yeah. Which you find on internal page 40. And 328 tells us the next step is to combine the separate judgments on the individual criteria. The rationale for the overall judgment must be clear,
Yeah.
demonstrating how susceptibility to change and values together contribute to the sensitivity of the receptor. Now, we know what the judgment was, the words, but we don't have any of that rationale, do we?
Correct.
Yeah. And as a result, it is a less transparent assessment, isn't it?
Well, there's no explanation
Yeah.
of susceptibility over and above the table,
Yeah.
in combination with its methodology.
Sure. Now let's just deal with the so what point here, please. Can you go back to CD 3.2? And within that, can you go please to page 3, PDF page 359, which is the Golden Farmland LCA?
So it's just taking a while to open.
It's in multiple places, but I'll take you to this one. Sorry, you might have it elsewhere.
Still struggling with the file, but I'll
That's
let you know
okay.
when it arrives.
That's fine. That's fine. If you've got the LVA open, have you got the LVA open
I
already?
do, yeah.
Yeah, I'll give you a different reference then. If you're in the LVA, so I haven't marked it up, but if you go to PDF 120 in the LVA,
120.
yeah, 120.
Oh, yes, yeah.
Yeah. So it's probably my fault.
Yes.
So are you there? Sorry, you are brilliant. Thank you. The sensitivity that is assessed at the LCA level is one of high sensitivity. Yeah. Top right corner. Do you see?
Yeah, yeah.
Yeah. Now the site sits within the northern site, I should say. That sits exclusively within LCA 38. Yeah.
Agreed.
And looking at the judgments that we've just seen in the appendix to Appendix B to the LVA, there's a difference. The LCA is telling us this is a high sensitivity landscape. The LVA is reaching a different view. It's stepped it down, hasn't it? It's gone medium high.
It does.
Yeah. Now, without that rationale that Olivia 3 talks about, we can't understand why the assessor has taken a different view to the published LCA, can we?
Not explicitly, but it does go on to describe negative elements within the site that are detractors of that LCA. So if you go to that section that we just discussed in the landscape character assessment,
Yeah.
and I'm just going back to that section of the summary of Yolding farmlands.
So could you just give me a paragraph reference? I'm sorry. Or page, or...
It's the PDF 117 of the LVA.
Yeah, got it, yeah.
So the Yolding farmlands is this sort of linear section in part between River Valley and the Scarp. And as you're running through that, it tends to identify summary of action: soften the impact of agricultural buildings and fruit equipment storage areas with native planting.
Yeah, so that's page 120, got it, yeah.
And 38.7 on, well, 38.7, it's a coherent pattern of elements provided by the consistency of the low-weld landform, frequent orchards and reservoirs along the foot of the Scarp. There are a few visual detractors comprising fruit packing equipment farms, pylons and polytunnels.
Yeah.
And when you go up into the assessment where it's identifying some of the elements of the site and the context, it's clearly...
Could you give me a reference, please?
Yeah, so I'm flicking around on the PDF, bear with me. It talks about polytunnels at the end of 4.44, page 31.
Hang on, 31. Sorry, PDF page 41. Just help me with the reference. Sorry, Mr. Williams.
No, not 4.44.
4.44. Okay.
Page 31.
Yeah, got it. Yeah.
It also talks about it under landscape value, natural heritage, and perceptual scenic qualities, so the detracting factors.
Yeah.
And it's not drawing the link between the two, but having read it, I can see the link between the two. Effectively, what it's saying is that of the wider LCA that's got a higher sensitivity, the site itself is predominantly accommodated by the visual detractors to that LCA, and inevitably the the sensitivity drops as a consequence of that. It doesn't explain that, but that's how I've read how they've come to that conclusion.
Right. Yeah, well, so first thing we can agree is it doesn't explain that.
It doesn't explain that, no.
The second thing, though, the LCA, when it reached its judgment of high sensitivity, it had already noted those factors, hadn't it?
Yeah, the point being, though, that it covers a wide area, that only smaller parts of it include those features, and this site is certainly the residential component, that's all it has.
Yeah.
So in terms of its sensitivity, inevitably, common sense, it would be less than the average for the wider LCA.
And even when we look at your 444, let's chase these references down. Final paragraph, a sentence of that paragraph. At the time of the field survey, polytunnels were erected for agricultural use on the land, but no judgment is said about them being a detractor, is it?
No, but it does go on to say that. So under perceptual scenic, so 459 on page 33, second sentence.
Yeah.
However, detracting factors such as the neighbouring polytunnels and the more modern elements of the adjacent settlement edge of Yolding prevent any pronounced sense of a scenic landscape. So it's clearly conscious of those detracting elements within that LCA.
Right, but this is in the section dealing with value, isn't it?
Yeah, but that's it's a part of the thought process to understand the fact that it's detracting a detractor on the site.
Right. It's not explicitly put. We've agreed that. Can I put it to you? This isn't clear, is it?
The link between what I've described and a medium sensitivity analysis is not direct. No. I agree
And
with
nor are any clear reasons given for reaching a different judgment to the LCA, is there?
It doesn't explain it, but it is obvious. It's a field full of polytunnels that are detracting factors in the LCA, and those polytunnels are only a small part of the wider LCA. Yeah. So it's not. It is unhelpful, and it doesn't explain that link. But I've read it afresh, and I can see why it's come to that conclusion.
And having a robust judgment on sensitivity is critical because of the impact that then has on your assessment of effect, yes?
It has a contribution to the overall assessment. It has no bearing whatsoever on the distinction between the expectations or assumed impacts of the allocation versus anything else to do with the appeal scheme. And that's why I've listed it under my rebuttal.
Well, let's follow that through. If the sensitivity, if you misunderstand your sensitivity, and your sensitivity is actually higher than you think it is, that is going to give rise to more adverse effects, yes?
Potentially, but when you look at Yolding farmlands, which is this LCA, the overall sensitivity is high-medium.
And the consequence of that, when you're designing a scheme, if you don't understand the sensitivity when you're designing the scheme, is you don't calibrate the mitigation that is required. That's right, isn't it?
No, that's wrong. That's totally wrong. I mean, it's very common for assessors to have a half-step difference in any case. The proposition you're effectively saying is the LVA says it's high-medium. The LCA, over a much wider area, without all the detractors, is high. There's a fundamental flaw in the judgment of high-medium versus high. There's a fundamental misunderstanding equals a fundamental misunderstanding of mitigation. That's just not correct.
Unless you get your effect correct, unless you understand what the effect is, you can't calibrate your mitigation accordingly, can you?
Fundamentally wrong, no. I've already explained this, that your judgment on mitigation and what's right and what's wrong for the site is part of the process.
Absolutely.
When you fix a scheme, you then assess the impacts.
And in order to do that process effectively, as you've described it, you need to understand as you go along what the sensitivity is, don't you? When your chartered landscape architect goes out, does their walk round, forms their initial views, and then feeds it into the design team.
Yes.
If that feedback is based on a misunderstanding of sensitivity, that is a flaw in the design process, isn't it?
If there is a misunderstanding, but I don't think there is, that they've assessed high-medium for a site that's full of polytunnels. The LCA assesses high, and by the way, we could get so drawn out into this, but fundamentally, Glivia and recent guidelines on from the Landscape Institute tells you one thing that's clear, and that is do not rely on the sensitivity assessments of LCA. That's the recent update that came out 4 weeks ago. There's a simple reason for that. Sensitivity is against a given type of change. The LCA doesn't assess a type of change. It doesn't identify a type of change. Drawing a parallel between the sensitivity in LCA and the judgments in an LVA is wrong. I won't go to town on that because it's a dry subject.
Sure.
But drawing a distinction between the two is professionally incorrect, and deciding or making a claim that identifying a high to medium sensitivity in the assessment process instead of high in an LCA that means the mitigation is somehow flawed is fundamentally wrong.
And because, as you say, the latest guidance is to form your own judgment, to do that work yourself, when that judgment isn't clearly explained, that is of even greater consequence for somebody assessing the work, because it's even more important, if you're not just going to rely on the LCA, if you're going to form your own judgment, it's even more important then that you explain it clearly, isn't it?
Well, yes. I mean, it would certainly help if there was a bit of a connection between the LCA and that judgment and report. That would help. But the answer to the so what is the judgment is right and reasonable, and it's not difficult to see that. The site is full of polytunnels. It's only half a step down from the sensitivity in the LCA, whatever we think about that. So it doesn't break the assessment process at all.
Finally, please, the photo montages. Can you go within the LVA? Can you go, please, to, for example, PDF 73?
Yeah.
We've got two photo montages. This one deals with year 0, and when we turn over the page, we get year 15. Yeah.
Yeah.
And at year 15, the woodland is given a height of 12 metres. Yeah.
Yes.
Mr. Kirkpatrick, in his proof of evidence, if I ask you to turn that up, please.
Yes.
And within that, so I'll give you the reference. It's 8. In fact, we could, let's do it like this. 8.3.3, please, on page 30, PDF 31.
Yes.
He gives two references. The IEMA is the principal one of those, and on that basis, and applying the IEMA guidance, he gets to a height of about 7.5 metres after 15 years. He takes no issue with the height of the other planet, but the woodland at 15 metres, that is inconsistent with the height suggested by the IEMA guidance that Mr. Kirkpatrick draws attention to, isn't it?
It is, on the basis that it's planted with whips.
Yeah.
It doesn't have to be planted with whips. I totally accept the LVA has said that it would be plantable with whips. But if a 12 metre high woodland was decided through the RM stage to be important, I alluded to this in chief, was decided to be important at the RM stage, there's a very simple solution to that, and then specify a number of extra heavy standards within the woodland mix.
But let's just chase that down. If they're not planted as whips, they're going to be planted as transplants, yeah?
Not transplants, no.
No? Well, how are they going to be planted then, in your view?
As extra heavy standards, or
Right.
even semi-mature.
Okay. And what height do you say they will get to then?
After 15 years?
Yeah.
Or comfortably above 10, and as much as 12 is distinctly possible, yeah.
Right.
I'm not suggesting all of it planted. A woodland mix would include a variety, and typically you would have transplants that are shrubs and understory. You'd have some feathered trees that might be planted at 2 metres. You might then have some extra heavy standards that's at 4.5 or 5. And if it's and I touched on this in evidence, if it's a very sensitive element that more height was decided was necessary at RM stage, you could specify semi-mature.
Yeah, right.
So you could get to 12 metres if that was deemed to be critically important.
Right. But to get to that particular approach has to be followed that you've explained. Yes.
Yes.
And there's nothing in the LVA that it suggests that we don't get told that that's what's been adopted when these photo montages were put together, do we?
No, you don't. But as I said, if it was deemed important at RM stage, that could be a request under the landscape reserve matter, and that's not uncommon.
Thank you. So that's all my questions. Thank you very much.
Thank you. Mr. Tucker, re-examination.
Sir? Excellent, thank you very much. First of all, an apology. I certainly wasn't saying by trying to stay awake that I was bored by my own friend's cross-examination. That was just my own afternoon needing caffeine, so please don't take offence, Mr. Henderson. That wasn't my intention. Though I accept it might have sounded like that, so you have my apology. Mr. Williams, I'm going to do this in reverse order and pick about 4 or 5 points, if I may. First of all, under the so what heading, I do like it when a meme of mine gets some traction. Paragraph 7.3.2 of Mr. Kirkpatrick's evidence, please.
Yes, have that.
Where does the point go in relation to the criticism of not describing the susceptibility, etc., the points that will put you in that context? So 7.3.2, if you look in about an inch down in that paragraph, do you see the sentence that says scarp slope is an important part of the landscape setting for the village, the effects of the setting should be fully recognised, the LVA doesn't do this. Do you see that?
I do.
Then it says, I do not agree with the assertion in LVA Appendix B landscape effects table the site has a settlement edge character, and then he explains his position.
Yes.
In terms of the comparative position between the authors of the LVA and Mr. Kirkpatrick, what do you take from that, and what, if anything, do you have to say about transparency of the LVA in that context?
Mr. Kirkpatrick makes that claim but doesn't actually explain it. The answer to the question, so what, is whatever the outcome of that process, whether it's agreed with Mr. Kirkpatrick or not, is it relates to both the allocation scenario and the appeal scheme. So it, as taking the approach in my rebuttal, it's not a distinguishing factor.
This issue about whether the site has a settlement edge character or not a settlement edge character, is that something which appears to have been clear to the author of this document or unclear to the author of this document?
I think it's unclear.
I see. Next, the issue about where the LVA process fits in. Can you turn to policy SA248 on page 282 of the local plan, please?
Yes.
And I just want to understand the words and what the role is of an LVA. So it says, the layout and form of the housing element shall be informed by an LVIA and incorporate both boundary and internal structural landscape that responds to the site's topography. See that?
Yes.
There's no commas in there, but there's plainly a subordinate clause in there. So I'm going to read it without the subordinate clause. The layout and form of the housing element shall incorporate both boundary and internal structural landscape that responds to site's topography. Does it?
Yes.
What about reserved matters? Will it?
Yes.
And then the subordinate clause shall be informed by an LVIA. What does that mean?
Well, it means that the process of producing an LVIA shall help shape the arrangement or extent of the housing element.
Has it?
It has.
Is there an obligation in the policy to set out and evidence each stage in relation to how it's been informed?
No.
I'll ask questions about policy to my witness, but in terms of any tension with that criteria, if one hasn't set out some of the elements of the degree to which the LVIA has informed it by not setting out meetings or whatever may have been said, What do you say about compliance or otherwise with that criteria?
Well, it's evident that it does. You don't need to chart that process to understand that's how it shaped the scheme. And I see it as slightly naive is the wrong word, but it's not. If it was written by a landscape professional, they would say an LVA or LVIA process, not a product. So I know I've made that point a few times, but it's quite important.
And my learned friend put to you a variety of things where you responded that, well, other scenarios have been modelled within the pre-app, and my learned friend then said, well, those aren't before the inspector, you've not seen them, you can give them limited weight. Material that's been produced in the pre-application process, is that material that's available to the council?
Well, yes, because they were there, and received it.
Had it been thought to be appropriate to scrutinise in a public forum, could the council have sought to produce it at this inquiry?
Indeed, yes.
Have they?
Not that I'm aware of. I mean, the pre-app letter is in there that demonstrates that photomontages were prepared in the discussion of options. So it is evidenced, but it hasn't been taken any further than that.
Is there any reason you've seen to go behind the accuracy of that correspondence?
Not at all. And I come back to the answer to the so what, is it's evident from looking at the scheme evolution that it's been shaped by that process.
We were taken to the charms of the LVA and Appendix C and the effect upon particular receptors in relation to Appendix C, and a proposition was put to you twice in relation to two separate receptors that because the change between construction, after construction and year 15 hadn't gone out of the same category, that was consistent with firstly mitigation not having an effect, and then secondly that being consistent with Mr. Kirkpatrick's view. I just want to understand how this works. Perhaps redolent of Richard Dawkins' tyranny of the discontinuous mind. These categorisations, whichever of these areas you're looking at, are these binary or do they describe a spectrum of effects?
They describe a spectrum, and they have thresholds where you step from one level to another.
So can one infer, if it's a spectrum, that because you remain within the same category, that there is no effect from mitigation? Is that something you can infer?
No. As I explained, that there's a fundamentally incorrect interpretation of the role of mitigation and its interaction with an assessment series of thresholds.
So if the proposition is said that there is no effect assumed by the LVA of mitigation if you stay within the same category, same threshold, or the same half threshold, same half category, is that the right way to look at the LVA or not the right way to look at the LVA?
It's the wrong way. It's the wrong way to assess the success of mitigation.
Can one infer consistency with Mr. Kirkpatrick's evidence in that circumstance? Does it support his case?
No, it doesn't. No.
Thank you. Yeah. Maths. My former head of chambers, Andrew Gilbart, used to love cross-examining on maths to no good effect. It's nice to know that somebody still does. It was put to you, and the maths are right, that 100 dwellings at 31 dwellings per hectare would still be about 30 dwellings per hectare, and that gives you an inferred geographical area for the site coverage for the housing of 3.23 hectares, which would then give you, instead of 200 square metres, 1,200 square metres. Do you recall that being put?
Yes.
And 0.12 of a hectare would give you some extra land for planting on, yeah?
Yes.
It's always good to look at the other side of the coin. If 31 dwellings per hectare is about 30, let's assume 29 dwellings per hectare is about 30.
Yeah.
What's the site coverage area that would give you?
3.45.
What's the site coverage proposed here?
3.35.
So 100 dwellings at 29 dwellings per hectare, would that give you a greater degree or a lesser degree of ability to landscape?
It would give you 0.1 of a hectare or 1,000 square metres less.
Should one consider both points or just the 31 point?
Well, I said in effort, I think you should consider neither, because they're trying to get into an answer to approximate, and my assessment's based on straight down the line, what's the difference? And there isn't a difference. But it does give you it gives you a rounded judgment on actually sticking with that 100 at 30 is a good assessment position.
And then let me take you on a trip down memory lane. You were taken to the Reg 18 plan at one stage. Don't need to turn it up. My learned friend rightly pointed out to you, well, the council at that stage, at Reg 18, were proposing approximately 100 dwellings on this site.
Yes.
I'll ask Mr. Ross whether or not that was subject to representations from the appellants, now, objectors then, but just assume for the purpose of this question that there were contrary representations in relation to site yield at that stage. Firstly, do you know when the local plan was actually adopted, so it became changed from being draft policy to actual policy?
Let me just check. Uh, 20th March 2024.
Yeah. So during the time that we had a draft policy of approximately 100, in parallel with that, we know the pre-application process was taking place, and then the application process took place in November of last year.
Yes.
Help me with this. When looking to bring forward a scheme in accordance with a draft policy, is one necessarily bound by a particular starting point in a draft policy, or should one look at things in a more holistic fashion?
I think you've got to apply your own judgment and look in a holistic fashion.
Thank you. But in any event, having looked at it in a holistic fashion, bringing all of this together, bringing all the points that my learned friend put to you together, what is the harm that arises from this scheme at 112 dwellings, 33.4 dwellings per hectare, as opposed to a scheme of, let's say, 100 dwellings, whether at 31 dwellings per hectare or 30 dwellings per hectare? What's the harm that arises?
I don't see any perceptual harm between the two positions at all.
Thank you very much. Sir, I don't know if you have any questions.
No, sorry, thank you. I don't have any questions. So thank you.
Thank you very much indeed, Mr. Williams.
So that essentially brings the evidence for today to a close. A couple of housekeeping items. I assume I'm getting a copy of the latest draft of the conditions in its tabulated form through this evening, so I can spend a pleasant evening going through that.
Sorry, sir. Yes, that's absolutely fine. We just need to quickly touch base with Mr. Scott after we've finished, and then we can absolutely do that. The document exists. We just need to square things up. Excellent. We just need to square things off between us, but we've also got your comments or your suggestions on the model conditions. They will be in there also.
Good, thank you. Why don't you work away on that merrily after the inquiry, and then I'll pick it up this evening to make best use of inquiry time. Latterly, then, I have the site visit. Do we have any particular ideas as how that might be arranged? Do I need to get myself a vehicle? There is a Enterprise Car Club car.
No, well, I'm sorry, Mr. Tucker. Our suggestion, Mr. Scott can drive. So if somebody would like to accompany you and him in the car, then he's happy to give everybody, or an appropriate person, and yourself a lift to the site. That's our suggestion. There might be better suggestions, but and Mr. Ross might have a better car, but that's our suggestion.
So the document that was submitted to me essentially was an itinerary, one map covering off a local site visit, if you like, of that immediate area, and then ones of much further wider views that the parties wanted me to go and look at. I'm aware that at the moment the likes of sort of Yalding Parish Council are not here, and that they might actually wish to participate in the site visit. which I think would perhaps lend itself best to the appeal site itself in that local area. And then yes, then if anyone else wished to, they could join us on a merry-go-round through these other sites. But yeah, that sounds like a not unreasonable way forward. If I've got a driver and someone coming from both sides of the party, then that seems to work well. And indeed,
Subject to Mr. Scott's car, self-evidently somebody, if we notify the parish council broadly what the time is going to be to meet on site,
Yeah.
then representatives from the parish council, I'm sure, could join in for the more distant view correct if they wish.
again, if they wanted to, yes, with their own transport, that's fine.
I agree. So, would we be able to fix some times just because we're going to get Mr. Kirkpatrick to join you on site, so to speak?
Yeah.
That,
Timescale wise, I would have thought we'd be finished by mid-afternoon. Yeah. So perhaps 3 o'clock.
3 o'clock on site.
I'm just using. Well, yeah, my understand. I mean, I don't know. No lunch.
No, I don't think that's unrealistic. I think if anything, you could be slightly earlier, but there's no point rushing.
Just going to add, yeah, certainly I'd hope with the work we're doing on the conditions and the Section 106 information we'll send over to you, I'd hope those elements, those sessions could be expedited one way or another. So it's probably more down to my evidence in terms of timescale.
But I think, yeah, 3 o'clock's not unreasonable, including travel time and the like, and frankly, if we're able to bring it forwards for some point, then we can do that on the day and secure the final exact date. But it'll be in the afternoon, probably around 3 o'clock. So that, thank you.
Additional document that to let you know is that the solicitors from our side that have drafted the 106, or that been involved in drafting the 106, have done a very short summary of what's in it, which was thought to be helpful in the event that there were third parties in the room. So that's been sent through to the case officer and the so that you can have sight of it and decide whether or not that's an appropriate or inappropriate document to place before you.
Well, it might be useful to be able to put it onto the core document library so public access to that.
Yeah, that's fine. I mean,
So they could.
I'm sure it's fine. I mean, I'm not going to like say, but given we've agreed everything, it's not contentious.
It should be just a factual summary of an agreed document, but I appreciate you'd like to see it.
Yeah,
Okay. Okay.
Basically fleshing out in the head in terms of the back and staying on common ground, just so that a layperson can pick it up rather than going, here's Thursday,
I don't know if you were going to raise it just on the sort of housekeeping bits. You also asked for an addendum to the planning statement of common ground to deal with the putative reasons for refusal that aren't pursued. That's been drafted. I think it's short, so I don't think it'll take us long to agree that with Mr. Scott, and that could be part of a bundle of information sent to you as well, just to clarify that.
Yeah, thank you. Excuse the belt and braces approach. That clearly was inferred in all of the evidence I've had before me, but sometimes it's helpful to state the absolute obvious, and there's nothing else weeks later that pops up. So thank you for that. That's most helpful.
So the only sort of 2 bits of homework that I've got noted down, one from our side, one from our friends, is we've been asked to find within the DAS what the numbers were of those 3 options, and we'll endeavour to do that overnight. My own friends now, I'm also searching for Mr. Ragnall's Valkyrie. You've got it, excellent.
Okay.
We'll endeavour to find that out overnight because we still need something to do in the next hour.
Grand, thank you. And then tomorrow, do we want to start 9:30 or 10 o'clock start?
9:30, so just to make sure that we definitely get outside.
Does that work or not work for you? With the live cast.
Fixed 9:30, sir. But if Mr. Scott isn't here, then we can always pause until he is. Yeah, 9:30.
consider it's got unnecessary stress for someone who's got to wear lots of hats as well as do their job at the inquiry itself. Fine. Okay. No, that's fine. I take both your points about coming in for an earlier start, but not actually 10 o'clock. We'll just start at 10 and plough on from there so that we can be in, we can get the live cast running so that anyone listening in from outside can get that. If needs be, we'll have a shorter lunch. If needs be, we'll truncate it. And I've already got an entire next week, if it all went horribly wrong, to be able to get through it, and I'd rather not rush it, and nor indeed people have to. They have lives outside of pins. I know right now my family is tearing their hair out with me being away yet again, as the inspector is also trying to persuade me to take on yet another inquiry to squeeze it in. But so there is life outside of pins. That's fine. We'll do 10 o'clock tomorrow. It is, yes. I think that makes, I've done it actually now more often than not with virtual closings. To my mind, it gets the benefit of all of it. It gives you the time to actually prepare good closings. I think that's helpful to everyone, in particular me. I still get them being presented to me so that nothing is lost in that presentation, but it does save the time and effort of people coming back to another location, particularly when it's on the second week when we haven't got anything planned. And by the looks of it at the moment, we're not going to need to slip into that other week as well. Okay.
And so you didn't ask the question on day one in relation to your costs, didn't take instructions with regards to costs, just in case there was any additional time we need to factor in for tomorrow.
Okay, no, I'd normally have come to that before I get off site and do that. Okay, thank you.
Could I just ask, it's on behalf of the parish, they're invited to the round table tomorrow,
Yep, if
aren't
they want to come along tomorrow,
Okay.
they're more than
Great.
welcome to.
Thank you.
To come along and see how far we get through. And do they have sight of the condition? I think they were sent on to them previously. Yes. Okay. Good. Thank you. All done there then? Everyone happy? Okay. Until 10 o'clock then we'll adjourn until 10 o'clock tomorrow. Thank you.